Partnership and Corporation Law. Section 2, Partners' Property Rights. So I am going to discuss Article 1810, 1811, and 1812. Article 1810. The property rights of a partner are: Number 1, his right in the specific partnership property. Number 2, his interest in the partnership. And number 3, his right to participate in the management. Enumerated in Article 1810 are the principal rights of a partner. So, to better understand these rights, I created an example to understand the concept. There are 3 requisites in the subject. Number 1, owned by the partnership as the juridical person in property. Number 2, tangible things. Number 3, specific in nature or determinate assets. For example, partners A, B, and C contributed tract, partial land, and money, respectively, in the partnership that they created. Here, all of the contribution is property of the partnership. Accordingly, the partners have co-ownership as they use it for the operation of the business. So, partners A, B, and C has the right over the tract, the partial land, and the money of the business. Number 2, if there is a contribution, there is an interest. For example, B contributed a land which is 500,000, A contributed the tract which is 300,000, and C contributed money worth 200,000. So obviously, B's interest for 500,000 is 50%, A is 30%, and C is 20%. So they base their interest on the value of their contribution. Number 3, when there is no stipulation as to which of them will be the manager, it only means that they can all perform in all acts of the administration. But if they appointed someone to be a managing partner, one or more, they have the rights of the management due to the major agreement of all the partners. Partnership property and partnership capital. Number 1, changes in value. Partnership property is variable. Its value may vary from day to day with changes in the market value, while partnership capital is constant. It remains unchanged as the amount fixed by agreement of the partner. For example, in partnership property, it is said that the partnership property can increase and can also decrease, unlike the partnership capital. The value will remain from the constitution of partnership until dissolution or liquidation. Number 2, assets included. Partnership property includes not only the original capital contribution of the partners, but also all property subsequently acquired with partnership funds, whereas partnership capital represents the aggregate partners' contribution. The partnership property is also larger because all the contribution are here plus any subsequent acquisition of asset using partnership funds or the partnership account. In the partnership capital, this is only the combined individual contribution of the partners. It can be cash, property, or services, and the value is fixed due to the partnership agreement. Ownership of certain property. Number 1, property used by the partnership. The use of such property by the partnership does not constitute ownership unless there is an express agreement. Note that the intent of the parties, whether the property in question shall belong to the partnership or themselves, is the controlling factor. Number 2, property acquired by a partner with partnership funds. The property is presumed to be partnership property unless a contrary intention appears. Note that if property is acquired after dissolution but before winding up, it would be his separate property, but he would be liable to the account to the partnership for the funds used in acquisition. Number 3, property carried in the partnership books as the partnership assets. These facts create a very strong inference that it is the partnership property. The inference is stronger if the records carry as a partnership liability an unpaid balance on the property. Number 4. Other factors tending to indicate property ownership. The fact that the income generated by the property is received by the partnership or the taxes thereon are paid by the partnership is evidence that the partnership is the owner. Note that if the partnership funds were later used to repair or maintain a property purchased by funds of an individual partner, it is not sufficient to assume that the property belongs to the partnership. Article 1811. A partner is co-owner with his partners of specific partnership property. The incidence of his co-ownership is that: Number 1. A partner is subject to the provision of this title to any agreement between the partners has an equal right with his partners to possess specific partnership property for partnership purposes, but he has no right to possess such property for any other purpose without the consent of his partners. Number 2. A partner's right in specific partnership property is not assignable except in the connection of the assignment of the rights of all the partners in the same property. Number 3. A partner's right in specific partnership property is not subject to attachment or execution except on a claim against the partnership. When partnership property is attached for a partnership debt, the partners or any of them or the representative of a deceased partner cannot claim any right under the homestead or exemption laws. Number 4. A partner's right in specific partnership property is not subject to legal support under Article 291 Civil Code Republic Act Number 386. Note that Article 1811 contemplates tangible property but not intangible things. A partner is a co-owner with his partners of specific partnership property, but the rules on co-ownership do not necessarily apply. The legal incident of this tenancy is in partnership are distinctively characteristic of the partnership relation. They are as follows. Number 1. Equal rights of possession. By agreement, the right to possess specific partnership property may be surrendered on the death of a partner. His right in specific partnership property vests in the surviving partners, not in the legal representative of a deceased partner. Number 2. Rights not assignable. A partner cannot separately assign his right to specific partnership property, but all of them can assign their rights in the same property. Example: in partnership A-B-C, partner A, B, or C cannot assign his right to the land, but all of them can assign their rights in the same property. Note that the law allows a retiring partner to assign his right in partnership property to the partners continuing the business. Number 3. Attachment or execution. A partnership property may be subject to attachment or execution only on claim against the partnership and not the partners. Example: in the same example, the land is not considered the separate property of A, B, and C. It belongs to the partnership as a juridical person, and a partner has no interest in it, but his share of what remains after all partnership debts are paid. Consequently, the land is not subject to attachment or execution except a claim against partnership. Number 4. Legal support. In the same example above, the right of A, B, and C to the land is not subject to any legal support, but their interest in the partnership is of course subject to legal support. Article 1812. A partner's interest in the partnership is his share of profits and surplus. The partner's interest in the partnership consists of his proportional share in the undistributed profits during the life of the partnership as a going concern, and his share in the undistributed surplus after its dissolution. So, profit. The excess of returns over expenditure in a transaction or series of transactions or the net income of the partnership for the given period of time. Surplus. The assets of the partnership after partnership debts and liabilities are paid and settled, and the rights of the partners among themselves are adjusted. It is the excess of the assets over liabilities. If the liabilities are more than the assets, the difference represents the extent of the loss. That's all. Thank you.